Well, dear colleagues, ladies and gentlemen, I'm delighted to extend a warm welcome to all of you for Professor Christoph Engel's inaugural lecture at the Center for Law and Economics at ETH Zurich. Your presence adds to the significance of this occasion, and we're looking forward to an enlightening and engaging session. Professor Engel will assume the role of Distinguished Senior Research Fellow at the ETH Center for Law and Economics as of spring 2024. This lecture marks the beginning of a multi-year cooperation between Christoph Engel and the Center for Law and Economics, focusing on the intersection of human-AI interaction and the law. Within the scope of this collaboration, we are also pleased to announce that Professor Engel has agreed to maintain a regular residence at our center. Professor Engel is the director of the Max Planck Institute for Research on Collective Goods in Bonn. He has also held chairs at the University of Osnabrück, at the Erasmus University in Rotterdam, at the University of Bonn, and served as the chair of the section of Humanities and Social Sciences of the Max Planck Society. Among the many prestigious memberships and honors bestowed on Professor Engel during his distinguished career, let me highlight his honorary doctorate from the Hebrew University of Jerusalem, his membership of the Academic Board of the German Minister of Economics and Labor, and his membership on the Board of Directors of the Society for Empirical Legal Studies. Professor Engel has been a towering figure in law and economics in Germany and worldwide. He's made many important contributions to the fields of experimental and behavioral law and economics. Recently, he has shifted his focus to explore the legal applications of machine learning and natural language processing. He has also had great influence on the next generation of legal scholars. Many of his former students moved on to important positions within legal academia. Professor Engel's presence, his intellectual curiosity, his boundless enthusiasm for research will undoubtedly energize and inspire researchers at the ETH Center for Law and Economics and beyond. Professor Engel, we are honored to have you here, and we are looking forward to your inaugural lecture entitled, "Do Large Language Models Usher in a New Era of Legal Research?" The floor is yours.
For everything in life, there is the right moment. And if you were to ask what's the right moment for an inaugural lecture, probably most people would say, well, if you are fast in your 30s, if you have been a little slower, perhaps in your 40s, but then it's done. I'm 68. So for me, it's a wonderful gift to have become member of this thriving center. It's my second visit now, and it's so enlivening. It's just a wonderful experience. I'm greatly looking forward to continuing. But this couldn't happen if there wasn't substance. And let me now, after the warm welcome that I give to the new center, delve into substance. And it's exciting times. That's essentially what I want to talk about today. The law and legal research, you could argue, have essentially not changed since Justinian. Except that perhaps now they do. And this is the theme that I want to explore tonight. I will show pieces of work where I'm enthusiastic and think there is great potential. But let me start with a note of caution. The AI Act is about to be adopted these days, and it defines as something very problematic and therefore high risk the following: AI systems intended to be used by a judicial authority or on their behalf to assist the judicial authority in researching and interpreting facts and the law, and in applying the law to a concrete set of facts. So essentially, what I want to present tonight is something that the legislator thinks is terribly dangerous. And I partly understand the legislator, actually, with part of my own work. Let me illustrate the cautious side with the infamous COMPAS data set. In the US, if a person is apprehended, the question to be answered is, should this person go to jail or should this person leave the courtroom on bail? Under US law, this question partly depends on the risk that the person recidivates before being tried. In many jurisdictions in the US, judges get a prediction by a machine learning model, by COMPAS. And this little thing I show you in the bottom of the screen is literally everything the judge gets. So on a risk score from 0 to 10, this case is 5, 8, or what have you. Probably the judge is led to believe that behind that, probably in less technical terms than what I use here, but intuitively, that something in the background is a nearly uniform distribution of the risk. So if you have the cutoff very high, ultimately at 10, then of course it can't happen that you have not jailed a person that should have been jailed after the fact. The other way around, if you put it at 0, the opposite side. But probably the judge will go somewhere in the middle and will intuitively think the risk of making a false positive decision, putting a person into jail that actually would not have recidivated, and the risk of making a false negative decision will be proportional to the score. And this intuition is correct if the underlying distribution of the possibility that one person in front of the judge is actually going to recidivate is uniformly distributed. You can also do the same exercise, the pictures look a little different, if you assume that it's normally distributed around some midpoint. Actually, the data in COMPAS, we have this wonderful ground truth that we can compare the prediction with the data. The data looks completely different. You see it now on the right-hand side, what the data actually looks like. The underlying distribution is heavily skewed. Most people in front of the courts in Broward County were actually never recidivating. And if the judge intuitively thinks along those proportionality counts, then it will be heavily biased to the detriment of defendants. Of course, a society may decide that among the two risks it had to balance, namely putting a person into jail although this person actually is not a risk for society, so protecting victims, or putting a person free, which is good for personal liberty, should be in some form balanced out. That's okay, but that's a political decision. And this political decision is not even visible to the judge, let alone to the policymaker. So the argument we make in that paper is you need to know the ground truth, you need to know the distribution, and otherwise this decision is just meaningless. So this is one illustration why things can indeed go wrong and why we should not be sanguine. Still, I'm deeply optimistic and think that the potential for change that comes from large language models is almost as big as the changes industry has observed with the advent of the steam engine. And I'll try to sketch possibilities where legal academia might change. It might be able to give more efficient service to the legal community. It might become possible to scale up the quantitative analysis of legal output. These are things that probably most people would have thought of. The third one is already a little less obvious. There might be room for objectifying doctrine. So the core of what the lawyers do and what always is argued is your personal judgment. could be to a considerable degree objectified. And as you heard, I'm by training more an experimental person, so there is a link to be built between experimental legal research and the availability of large language models. And the most daring is what I have called virtual legal history. You won't understand it right now, but I'm happy to explain in a minute. So let me start with the most pedestrian, the law professor as a serviceman. Let me illustrate this with the following case. The police raids a journalist's office because it wants to find the identity of a whistleblower. Is that legal or is that illegal? Actually, there is jurisprudence on that, and if you want to learn it, you would probably quickly think that might be a violation of the European Convention on Human Rights, and then you might check out one of, in German we call them commentaries, one of the summarizing of where doctrine is. And Beck Online has a nice commentary on that, and you would check out this paragraph, which exactly speaks to the issue. And if you want to plead in court, the next step you would want to have is lawyers love footnotes, so you would want to have enough footnotes. So here is a list from which you could pick. And once you have arrived there, you would certainly also say, wait a minute, this is Council of Europe. The Council of Europe often does a good job, and indeed it does. So if you Google a bit, you will find this nice document, which is an excellent summary of the jurisprudence. Fine. So we have something here. How is that composed? The process is the European Court of Justice makes one ruling, and you have to summarize it as a law professor writing a commentary. It does the same thing again, it does the same thing again. Probably it's more than 3, but I didn't want to put too many things on my slide. And then you summarize the summaries. So that's essentially what a commentary is about. And then the commentary is being published, and then the court continues seeing cases, and there comes a new case, and then the summary has to be updated. I argue all of that can be made automatic. Let me illustrate this with the landmark case on the little thing I started out with, the case of Nagla versus Latvia. The critical doctrinal question is whether this raiding by the police is necessary in a democratic society. At that point, the lawyers have to engage in balancing. So they must weigh the competing pros and cons. The court does so over 3 pages, and you can ask either GPT or Gemini. In this case, I thought Gemini is a little more accessible to summarize the ruling for you. I won't read it out. That's not our business tonight. And then you have all your summaries, and then you push all your summaries to in the next prompt to GPT and say, please summarize my summaries, and here it is, and it pretty much looks like a commentary. So the output of GPT looks pretty much like the products many law professors generate. And the good thing is that the law professors, even the very diligent law professors, may update their commentary once in a year, and there's only very few of them that are updated once in a year. It's much more plausible they will be updated every 5 years or so. In my case, I have my machinery running. There's the next case. I can just have it integrate, and it puts it at the right place. It looks very convincing. So my conviction is the commentary business is dead, because we just have a better technology for doing the same thing. And actually, with one of my research associates, we are trying to roll it out on a German case. The toughest part is, of course, you must classify legal questions. In the case of the European Convention on Human Rights, that's an easy one, because the underlying law has a very clear structure, and the court always argues along that structure, so it's not difficult for you to put things into boxes. But with other legal questions, that's more difficult, and at that point, I guess we are not yet there. That will take some time until computers can take over. Why is that appealing? Well, honestly, professors are expensive, so we can do the same thing much cheaper. But more importantly, we can go into the long tail. There is, of course, a commentary on the European Convention on Human Rights, but a few decades ago there was only a single one by Vorwein, and even before that there was none. There is many parts of the law that don't have enough demand or not enough specialization from the professors, either may be the reason, so that simply there is nothing. And now we can easily deliver. And most interestingly is what I already illustrated. You can turn the commentary into a living document. So the next day when the ruling has been published, you can update your commentary, which was not possible in the past. Second thing, let me illustrate is, of course, I hope not too many RAs are in the room because this is meant to portray RAs at work, and probably they don't have to wear caps and they don't have to stand while working. But in a way, the RA business is something where you have one well-defined task and you buy yourself into getting this standardized task done by as many as you need. And to a degree, this is something that we can shift over. So here, what we're looking at is law as data. And it's interesting because we can scale up feature extraction as this industry would usually call it. Let me illustrate this with another piece of my own work on the German Constitutional Court. The question on which I already have a draft out is whether the nominating political party predicts case outcomes. In the US, that's a whole industry. In Germany, most people think no. Essentially, they are right. At least that's what my data suggests. But still, it's worth investigating more clearly. There's a challenge because the German Constitutional Court always decides in panels, either chambers of 3 or senates of 8, and the votes are not disclosed. But there is a proxy. There is always a justice referee, and that one is not disclosed either, but it can be reconstructed. Because the justices have fixed dockets by domain. So if I know what the case is about, then I can say who must have been the justice referee. And that's something I was interested in for quite some time and had approached a wonderful colleague who actually, I'm very proud to learn, will be in Zurich in November, Jordan Boyd-Graber, a wonderful machine learner. And we thought, well, that's a task for natural language processing. And we worked on it for quite a while, and doesn't look good. And the reason why it doesn't look good is, in a way, straightforward. We have a little more than 8,000 rulings and 114 different domains. And the balance over those domains is very unbalanced. So we have a few for which we have hundreds of cases and others for which we have only a handful of cases. So the brute force approach with natural language process topic modeling simply doesn't work because the data doesn't allow. Well, that was disappointing, and I thought there must be a way. I still wanted to have my answer. And I embarked on something, honestly speaking, very laborious because I iteratively refined a list of keywords, so a dictionary approach, as the computer scientists would call it. And I identified keywords that arguably stand for one of those 114 domains and went through several loops to make that even better. And the result is not so bad. If you look at the first synod, I'm still working on the second, it's a lot of stuff. Then for 2010 rulings out of a little more than 4,000, I have a unique domain and can infer from this unique domain who is the justice referee. I have 406 cases where just is not enough information, so we will never know. But the puzzling part is the remaining, where I have more than one possible referees. So a chamber has only 3 justices, so it can't be more than 3. So if I have 3, I know nothing, essentially. And I wanted to go beyond that. And I thought, maybe I can now exploit the power of GPT. And in the next step, what I did is I gave to GPT-4 the text plus only the candidate domains that I still had. So not 101, but 2 or 3. And then asked it to justify the ruling and to give me the result. I checked so many. They're superbly good. I didn't find a single one where I would not have been convinced that this was the right answer. I could, of course, have done it myself, but if you do more than 1,000 cases, that gets a bit laborious. So here, indeed, I can do that. Now I'm near perfect. I have 5, and for the 5, it's an obvious reason why I can't find it, because the same domain is in the docket of more than one justice who is on the chamber. Then hopeless. Occasionally that happens. And interestingly, it also matters for outcomes. So if I now classify outcomes by is success in line with the political conviction of the party that has nominated this justice referee, then you see not on the merits, happily, but on less important outcome measures like success on a preliminary ruling or on procedural matters, we do indeed find a significant effect. That's not something to be scared of, so I'm not saying German Constitutional Court is bust. To the contrary, it's in a way comforting to say that, well, for the minor stuff there is something, so they are not angels. But for the important stuff, there is nothing. So that's more the message I can come up with. One step more daring, can we make justice itself more measurable? Here we have to say a few more words about methodological challenges, because thus far I have been lazy. I have just asked once. I've taken the best available large language model that I could get, which currently is GPT-4. If I was in doubt, I have checked my results manually, and that was okay because all I had to convince was the scientific community, and I can make a case. If I want to make doctrine measurable, then what I'm doing may matter for people's lives. So we really should be sure that we are getting things right. And also, with doctrine, it's much harder to say what's the ground truth. I mean, in the cases I looked at, I could either with my own professional expertise or because, in the Compass case even, because there was outside data, I could say I know what it should be and could compare it to what is coming out. Here, that's more shaky. And this is interesting or relevant because the ability to make doctrine more measurable matters precisely if there is no logically right or wrong answer. So what we want to know is which are plausible interpretations, how much support do we get for them? And that's not something that could never be measured, but it's considerably more daring than my previous question, and therefore we have to think harder. So I guess for many people in the room, this is plain useless because you know that, of course, but just to have everybody on board, let's have a quick look under the hood. What does a large language model do? It does do next word prediction, and everything it does is probabilistic. Unfortunately, in the high-end large language models like GPT or Gemini, these probabilities are generated, but they are not disclosed. But there is a way to reconstruct the probabilities. You can ask more than once, can allow the model some variance, so that's a parameter usually called temperature that you can manipulate, and then can plot distributions. So we get a chance to exposed look under the hood, and that's interesting for the purposes I'm addressing here, because there is no right answer in the strict sense. So it's important for me to get a sense of, is a certain response an outlier, or is a certain response a plausible candidate? Now, I'm so glad with Johan Hermstruve and Alison Kim, they're both in the room. We have a nice joint project, and there we have also compared two large language models, namely 3.5 Turbo and 4 from GPT. And I don't have time to explain the details of what we are doing here. The important part for here is they look very different. So depending on which model you use, you either get a majority opinion. That's essentially what happens with GPT-4. It's super good, so the quality is very high, but the price you have to pay for the high quality is that you no longer see the distribution. Whereas if you use the so-called worse model, the worse model still gives you the distribution. And if normatively you are interested in the distribution, then it's better to use the large language model that's not so good compared to the one that's super good. Actually, yesterday I had a nice conversation with one of my computer science colleagues who was super interested in that finding and said he did not know of any computer science paper that made the point. So probably it's even worth writing a little paper on that. So what are we doing? Actually, this is near my home, and some dentist thought it's a good idea to put these rusty cars into his garden. I thought this is a nice illustration of a topic that every legal theorist has, of course, heard more than often: no vehicles in the park. So how do you interpret this rule? There is quite some room, and in the US it's an even more interesting question, as normatively speaking, the majority of the legal community these days argues that responses to such questions should not be given by the experts. They should be given in the sense of what the law's subjects, so the people in the street, would think. And therefore, that is something which we can ask a model that has not been specialized on telling us what the legal expert is. That's what we have tried. So we asked, is one of those 25 things a vehicle? And we exploited the fact, so you see Tobia here, that a person who was part of the center, Kevin Tobia, has done an experiment with human subjects on that. So we have a comparison. And if we simply, that's the left panel, if we simply ask the same question that he asked, the GPT, you see, that's not looking really convincing. Because GPT, so that's the red ones, makes a few differences, but they are not great. And the human subjects discriminate much more strongly between different vehicles. But if we then change the prompt and no longer ask, do you, GPT, think this is a vehicle, but rather say, so and so many participants have been asked by Kevin Tobia, do you think they have answered this is a vehicle or not? So if we ask for beliefs, as the experimentalists would call it, then on the upper end we are pretty close to what the human subjects say. On the lower end, it's still overconclusive. So it's not perfect, but at least with working on prompts, there is a chance to get better. And then things we did, so we asked literalism versus textualism. So on the legal theory side, most people would argue that what you want is not to know whether a vehicle is a vehicle, but whether, knowing that you want to interpret the legal rule, no vehicles in the park, something is a vehicle. So that's the distinction between literalism and textualism. And you see it makes a difference, but it's not a huge one. Then you can go historical, so that's what the Americans debate would call originalism. And there's two versions of historical meaning. The one being that you just ask for the interpretation of the term in abstract terms, or that's the intentional approach, or that you ask for typical illustrations of the term at the time when the rule has been introduced. That's the extensional term, and we find a few differences, again, not huge. And what I was really surprised of is that GPT doesn't seem to be a purposivist. So I'm a German lawyer, so we always think these textualists, they are run crazy. I mean, the obvious thing you want to know is what's that rule good for, and then we decide along those lines. And I was expecting that if we deliberately instruct GPT to decide by the purpose, and we had people do not want to be annoyed, there could be an accident, there's not enough space, and so on, that we would see strong differences. And what you have to look at is within each of these individual objects, whether the bars have different size. And you see, well, not much. On the lower end, we see a little bit, but it seems GPT is not a purposivist. Okay, moving on to my original domain, which I still don't give up, namely experimental legal research. How can experimental legal research benefit from the availability of large language models? First, if you are just interested in hypotheticals, you can, of course, just ask GPT. So you can have your vignette and run your vignette with GPT and can scale it up, can do robustness checks, as many as you want, and most interestingly, have a chance to say much more about heterogeneity. Because most of the effects that we find are not human universals, rather we find variance, and usually this variance is patterned. So usually we have peaks at certain parts of the distribution. And shifting it one step further, most of the things we are interested in are not one-dimensional, but are multidimensional, and then the cells get super small, and with human subjects you quickly run into practical impossibility. But you can ask the LLM a few thousand times if you want to fill all cells. So there is at least one advantage. You can even do choices with choice experiments with large language models. So you can have them be a participant in your game and can see what interaction, what response they give to each other, and you can also do something which becomes increasingly practical in our lives, that we no longer interact with humans, but we interact with computers. And then you can see how do human choices change, and how do computers react to the fact that they no longer interact with each other, but with another human participant. So that we did. We have programmed a tool that makes it easy to do that. So if one of you wants to work along those lines, we can. It's online, so you can just pick the software and use it for your purposes. So the first thing we checked is, do large language models, when interacting with each other, respond to framing? So to the way how the case has been presented to them. And we see strong framing effects here. Actually, much stronger with GPT-4 than with GPT 3.5. But even more interesting probably for this context is that we then did the same experiment, so it's a 2x2 prisoner's dilemma, so as simple as it gets, and now had a human participant interact with a large language model. And if you go back to this, all lines are essentially flat, except in the first round. But then it stabilizes at some level. The levels differ depending on the frame, but in principle, if GPT interacts with itself, it's pretty cooperative and stabilizes behavior pretty fast. So it seems to understand that this is a social dilemma, and that the collective best way of reacting to a social dilemma is cooperation, which you try to convince human participants of, and sometimes it works, but usually it doesn't. Now, if we bring in a human participant, then the picture looks completely different. So on the left-hand side, it's only GPT's choices that I represent here. On the left-hand side, you see that GPT is no longer stabilizing. It's showing this downwards slope that we know from tons of human experiments. So apparently, the LLM is not naive. It responds to the fact that humans are not trustworthy to the degree that it believes itself to be trustworthy. And therefore, it slowly goes down its possible interpretation. I'm, of course, doing exposed interpretations of things where I only see the results. Even more dramatic is the right-hand side of this graph. Because if the human in the first round, so it was a sequential prisoner's dilemma, so the GPT was drawing first and was always cooperating in the first round. We didn't program it, but that did it on its own. And then in the second round, the human reacted. And if in the second round the human was nice, then you get the picture, the left-hand picture, still not good, so no trust. But in the right-hand side, you see it just goes down. So it immediately punishes deviations from cooperation. So The nice insight is computers are not naive. They're actually forcefully executing what they think should be done. And unfortunately, they didn't even go back. So they are maybe overly skeptical even. All right, the most daring thing in the end, virtual legal history. What are we trying to do here? This is the biggest technical challenge in that for this, it's not enough that we use existing large language models. Probably it will also not be enough to fine-tune existing large language models. Probably we must train large language models from scratch, or at least very basically. So that's now big machinery. And it's a big team. So let me start from the bottom, because Stefan Bechtold is part of the team, as is Jens Frankenreiter. Some of you will remember him because he was a member of the group as well. And then two American lawyers, Mike Livermore and Redit Abibi. The latter is in Harvard and the first is in Virginia. And the upper row is computer scientists. So that's two of my Max Planck colleagues, Krishna Gumadi on the left-hand side and Moritz Hart on the right-hand side. And that's wonderful on two grounds. The first, most important ground is, of course, we have wonderful expertise in the team, but also on the money side, it's expensive. And they have more money than we do, even in my Max Planck Institute. And the two heavy lifters are the two guys in the middle, Vedant Nanda and Rodrigo Dominguez. So what is this big team doing? We try to generate a large language model that's not only specialized to legal tasks, that's one arm of what we are doing, but that is even only using legal data. So we are working with two corpora, the data from the Supreme Court in the US and the data from the US appellate courts. And not only is that a considerable amount of data, in both cases from the beginning of their activity, but the big advantage of those two data sets for our purposes is they are labeled, meaning that tons of those poor RAs over decades have given us classifications. So we can extend those classifications and check not only whether our own classifications are any good, but we can even use them to supervise learning. And the big surprise in the last team meeting was how good it becomes if we allow for supervised learning. So all of a sudden, we can push the accuracy rate in the order of already 90%. So I didn't want to believe it almost when I saw it. Okay, that was the advertising for the thing, but now back to why it might be something interesting for legal research. If we train things slice by slice, so let's say we train until 1803 and only use the part of those legal data sets that has already been available at that point in time, and then ask it questions that the legal discipline only had to ask 50 years later. And if by that doing we kick out key moments in the development of the law, like Marbury versus Madison, so the ruling giving the courts the power to strike down anti-constitutional statutes, we can say how the law would have developed had that landmark change not happened. This is, of course, borrowing from something that in history is quite fashionable. Virtual history is a whole line of historical research, only that's pure speculation, whereas we have data. So I very much hope that we will be able to isolate development path through time. So let me end on, I hope I have convinced you that for legal research, these are just exciting times. And let me draw a parallel to Earth systems trends. Usually there people say this is very bad, and they show us those graphs to scare us off. because in human development, in Earth development, after human intervention, things have rocketed up. But I can imagine that 10 years from now, 20 years from now, we can draw similar pictures for legal research. There's so much potential that it could just explode, and that the pre-steam engine, the pre-large language model legal research may just look pretty dated. I'm not saying this is going to happen, but I see the possibility it might be happening, and I'm so glad I'm standing here to say I'm starting something new at age 68. So very much looking forward to doing that with all of you together.